Hello everyone, good morning to all. Welcome to the new session of our e-learning class. I am Rasmi Ranjan Mishra, lecturer of UN Autonomous College of Science and Technology. Today I am going to discuss on a subject regarding business and corporate law. So on today's discussion, I am going to discuss in front of you relating to a chapter that is performance of contract. So let us come together, join with me, watch my video. If you are having any doubt, then you can give your comment in YouTube comment section. So what do you mean by performance of contract? Contract is said to be performed when the obligation of the parties are fulfilled completely or partly, and hence contract is discharged. We can say that performance of contract means when parties to the contract involved, they are fulfill or complete their obligation either wholly or partly, and there is nothing to do from either side. In that case, we can say that there is a performance of contract. So that performance of contract may be of two types. One is actual performance, another one is attempted performance. Actual performance means when contract is already performed by both the parties involved in the contract and there is nothing to do. In that case, that is called as actual performance. But attempted performance, that is said as contract is going to perform by either of the parties. That means there is still to be performed something else from either side. So it is also known as tender, or that is also called as offer of performance. So now we are going to discuss what is actual performance and what is attempted performance. So the first one is actual performance. When both the parties to the contract fulfill their obligation as per the contract, the promise is said to actually performed. That means the parties to the contract involved in particular obligation, when they all fulfill their obligation what they enter into at the time of forming the contract, or what the promise is said to be performed by both the parties. In that case, when it is actually performed, in that case that fulfills their obligation, and we can say that actual performance. Actual performance gives a discharge to the contract and the liability of the promisor ceases to exist. So that means when contract is said to perform what the parties enter into and there is nothing to do or nothing to complete or nothing to else to be performed, and it is actually performed, in that case the liability of both the parties that ceases to exist and the performance gives rise to discharge of contract. So there is one example. P agrees to deliver 100 sacks of mangoes to Q, and Q promises to pay the price on delivery. So in this case, P delivers the mangoes on due date and Q thereby makes the payment, and this is called as actual performance. Here the contract involves with the two parties, that is agreement made between P and Q, and P said to Q that he is going to deliver 100 sacks of mangoes, and Q in return also promises to pay the price of the mangoes what the P said at the time of forming the contract. In that case, P's duty is to deliver the mangoes on the appointed due date and Q's duty is to make the payment to P. In that case, both the parties fulfill their respective obligation and there is nothing to do from either side, that is either from P or from Q. So this is called as actual performance of the contract. The second one is attempted performance, which is otherwise known as tender or offer to perform. Sometimes it so happens that promisor offers to perform his obligation under the contract at the proper time and place, but promisee does not accept the performance. This is known as attempted performance or tender. That means the two parties involved in the contract, one is offerer or promisor, another one is offeree or promisee. So here promisor offers to perform his obligation as per the contract made, and that is at the proper time and place, but other side the promisee that does not accept the performance what the promisor offers to perform. In that case, that is called as a attempted performance. That means one party already perform or promises to obligation his duty, but other party does not interested to accept that performance what the promisor already is going to perform. So this is known as attempted performance. If goods are tendered by the seller but refused by the buyer, so in that case the seller is discharged from further liability. That means seller's duty or obligation is to sell, or goods are tendered by the seller, but when the buyer refuses to accept it or to purchase it, in that case seller is discharged from all type of further liability, given that the goods are in accordance with the contract as to quality and quantity, and he may sue the buyer for breach of contract if he so desires. So if the quality and quantity what the buyer prescribes, and as per that or in accordance with that quality and quantity the seller already performs that, in that case the seller sue the buyer for breach of a contract and can recover the price or damages if any, if the seller wants to desire it. So what is offer to perform? This is mentioned under section 38, where a promisor has made an offer of performance to the promisee and offer has not been accepted. The promisor is not responsible to non-performance, or nor does he thereby lose the rights under the contract. So there is one simple example to perform or offer to perform. We have become very clear. So there is example is A contracts to deliver to B 100 tons of basmati rice at his warehouse on 6th December 2015. A take the goods to B's place on the due date during the business hour, but B, without assigning any good reason, refuses to take the delivery. That means what the B wants to take, as per that A is going to deliver or already take that goods at the place of B, but without having any good reason B refuses to take that or accept that delivery. Here A has performed what he was required to perform. That means as per the obligation of A, already he has performed what was required to perform. It is a case of attempted performance. That means from one side that is performed but other side that is not performed. So that is a case of attempted performance, and A is not responsible for non-performance because A's obligation already fulfilled. What the agreement made by B with A already that is performed by A. So A is not responsible for any type of a non-performance of B, nor does he thereby lose the rights under the contract. So now we are going to discuss what is the requirements of a valid tender, or which is called as attempted performance. The first one is it must be unconditional. That means when attempted performance is made, that is does not based upon any condition. And the second one, it must be made at a proper time and place. So the time and place that must be fulfilled, and as per that, that has been made. Third, a person to whom the tender is made must be given reasonable opportunity for inspection of goods and articles. The fourth one is the tender must be whole and not of the part. This is very important. Must be made at whole, not any part. The next one is the tender must be in proper form. That means tender of money in current coins. So now we are going to discuss what are the requirements of a valid tender, or in order to become a valid tender or offer of performance, what are the basic requirements. The first one is it must be unconditional. That means it does not based upon any condition. Second, it must be made at proper time and place. So that is very important. Time and place must be mentioned at the time of offer of performance. The third one is a person to whom the tender is made must be given reasonable opportunity for inspection of the goods or articles. So that means the buyer or the person to whom the tender is made, that must have been given a reasonable opportunity to inspect all type of goods regarding quality, quantity, purity, everything. Then the tender must be whole and not of the part. Next one is tender must be made in proper form. That means tender of money must be in current coins. Next, tender must be made to proper person. Next, tender for the delivery of goods must be for the quality, quantity as stipulated in the contract. That means what the quality, what the quantity that is made at the time of a performance of the contract, that must have been made at the time of a delivery of goods. Next, tender made to one of the several joint promises has the same legal consequence as tender to all of them. This signifies that where there are several joint promises involved in a contract, in that case tender made to any one of the several joint promises means the tender to all of them. That means it has same legal consequences as tender to all of them. Now we are going to discuss a contract which need not be performed. There are several grounds where the contract is not performed. The first one is mentioned under section 56. That means when its performance becomes impossible. That means the contract to perform, if it becomes impossible to perform by either parties, in that case the contract need not be performed. The second one is mentioned under section 62, when the parties to it agree to substitute to a new contract or to rescind or to alter it. That means when the parties involved in the contract, either they cancel that or they want to change that or they enters into substitute with a new contract, in that case the original contract need not be performed. The third one is when the promises dispense with or remits either wholly or in part the performance of the promise made to him or extend the time for such performance or accept any satisfaction for it. That means when the promise is made either wholly or in part, that dispense the performance of the promise made, and in that case if it extends for time for such performance or accept any satisfaction, in that case the contract need not be performed. This is mentioned under section 63. The next one is mentioned under section 64, when the person at whose option it is voidable rescind it. That means the parties to the contract or what the contract they perform, if it is a case of a voidable contract, in that case the original contract need not be performed. Next, when the promises neglects or refuses to afford the promisor reasonable facilities for performance of promise, in that case the contract need not be performed, which is mentioned under section 67. The sixth point, when it is illegal, that means contract if it becomes illegal, in that case that is not performed by either the parties. Then the next part is by whom contract must be performed. The first one is by the promisor. In this case, contract involving personal skill, taste or diligence of the promisor, that means contract to paint a picture, a contract of agency or service, the promisor must himself fulfill the contract. Section 40 states that if it appears from the nature of the case that it was intention of the parties to any contract that any promise contained in it should be fulfilled by the promisor himself, such promise must be performed by the promisor. So promisor means the person who wants to promise the contract or perform the contract. If that person perform that contract, in that case the contract is said to be performed by the promisor himself. So there is one example, A promises to paint picture for B, A must fulfill this promise. So that means here A is the promisor, he promises to paint picture for a B, and in that case that must have been fulfilled or performed by the promisor A. The second one is by the agent. When the contract is of impersonal nature, that means personal consideration is not the foundation of the contract, a competent person can be employed to perform it. If the person involved is not the foundation, in that case that can also be performed by its or his agent, which is mentioned under section 40 subsection 2. There is one example, A promises to pay B a sum of money. A may fulfill this promise either personally paying the money to B or any person appointed by A as his agent to be paid to B by that person. So either by the promisor, if the promisor is not there, in that case the promisor must be appointed one person on his behalf, which is called as his agent. The third one is legal representative. In case of a death of the promisor before performance, the liability falls on his legal representative unless contrary intention appears in the contract. This is mentioned under section 37. But contract involving personal skill comes to end on the death of the promisor. So there is one example, A promises to paint picture for B for a certain date at a certain price, but before that day A dies. So in that case the contract cannot be enforced by A's representative because A is bound to perform to paint the picture, but his representative is not having that skill to paint the picture for any other person. Another one is A promises to deliver goods to B on a certain date on payment of rupees 1000, but A dies before that day. So in that case, A's representative must be bound to deliver, because delivery of goods may be made by the promisor, or if the promisor is not there or dies, in that case any representative can perform that. But paint picture is not having the skill or art for any other person of the promisor's representative. So in certain cases that is performed by the legal representative, but in certain cases that is also not performed by the legal representative, because that involves with the personal skills. If the personal skills is not there, then in that case the legal representative cannot be performed. The fourth one is third person. If a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promisor. There is one example. A wanted to sell his property to B. A and B both enter into the contract for sale of the property. A suddenly fall ill, and therefore, though power of attorney authorized by his elder brother, E perform the contract on A's behalf. In this case, B afterward cannot enforce it against the promisor. Fifth, that is joint promisor. When two or more person makes a joint promise to promisee, all joint promisors are bound to perform the contract. So example is A, B and C, they jointly enter into the contract with E for sale of the purchased property. Here A, B and C are equally liable for performance of contract with E. So that is called as a joint promisor. Next one is who can demand performance. It is only promise who can demand the performance. Only promisee can demand the performance of the contract. This makes no difference that whether the performance demanded is for the benefit of the promisee or for the third person. In case death of the promisee, before performance, legal representative must perform with demand, or must ahead or move ahead with demand. One example, A promises to pay B. A promised B to pay C a sum of rupees 10,000. A does not pay the amount to C. C cannot take action against A, and as it is only B who can enforce the promisee against A, because A promised B, so B must take action against A, but C is not liable to take action against A, because A is not make contract with C directly. Then now we are going to discuss what is time and place of performance. Performance of promise within a reasonable time, which is mentioned under section 46, where the time for performance is not specified and the promissory himself has to perform the promise without being asked by the promisee. The contract must be performed within a reasonable time if no time is mentioned. And that question of reasonable time is very important, because the time which is affordable from both sides. Next, performance of promise where time is specified. If time is specified, that must have been performed within that specified time or during the usual hours of the business on such date and the place at which the promise is ought to be performed, which is mentioned under section 47. Next part, performance of promise on an application by the promise. If it may also happen that the day of the performance of the promise is specified in the contract, but the promisor has not undertaken to perform without any application or demand by the promisee, and in that case the promisee must apply for performance with a proper place and within the usual hours of the business. Next, performance of promise where no place is specified and no application is to be made. This is mentioned under section 49, which says that when promisee is to be performed without any application by the promisee and no place is fixed, it is the duty of the promisor to apply promisee to appoint a reasonable place for the performance of the contract, and that must be performed with such place. Next, fifth point, performance of promise in the manner and time sanctioned by the promise. Sometimes the promisee himself prescribe the manner and the time of performance, and in that case the promise must be performed within that specified manner as well as the time prescribed by the promisee. The promisor shall be discharged from all type of liability if he performed the promise in the manner and the time which is specified by the promisee. The time as the essence or the most important of the contract. Time as the essence of contract means performance of promise by a party shall be within a specified time, or if no time is specified, within a reasonable time. Section 55 says time as the essence of the contract. That means when time is the essence in a contract, where time is the essence of the contract, and there is failure in performance within that specified time, then the contract is said to as voidable contract at the option of the promise. If promisee accept the performance of contract after the specified time, then in that case promisee is not entitled to claim any type of compensation or loss suffered due to non-performance of the contract on the appointed time. The second one is in commercial or mercantile contract, which provides performance within a specified time, and the time is ordinarily the most important or essence of the contract, as business wants certainty in respect of its business. If no time is the essence, or if time is not the essence, in that case it do not make the contract voidable, rather the promisee is entitled to claim any type of a compensation or a loss suffered due to non-performance. Intention to make the time as essence of contract, if it expressed in writing, must be unambiguous and without any mistake. In case of a commercial or mercantile contract, in time is not the essence, the presumption is that time is not the essence of the contract. In that case, the contract of sale of immovable property, time is not the essence unless it is shown that intention of the parties was that the time should be the most important or essence of the contract. So this is all about regarding the performance of the contract. So in today's class we have completed all the parts relating to performance, types of a performance of contract, and by whom the contract must be performed, by whom contract is not performed, what is time and place of performance, and regarding to that various presumptions regarding time and place of performance of a contract. So hope you students all have cleared about today's class. If you are having any doubt, then you can give your comment in YouTube comment section. Thank you. Have a good day to all of you.